All rise.
And we're still with Brian.
My Lord, I think we finished, Brian.
Could you, I don't know whether it's possible to fit it in this time. You mentioned Alconbury earlier, and there's just one passage in paragraph 117 in Alconbury that I'd like you to help me with.
Certainly.
Presumably this is in the bundle somewhere, is it?
It is in the bundle.
32,
Yeah.
22.
22.
22,
Volume
yes.
4,
and it was
22.
paragraph 117, which I just wanted to see that I understood what Lord Hoffman was saying. As you were reminding us, Lord Hoffman goes into some detail in picking up Mr. Bratzer's opinion, and obviously uses it in his line of thought. And at 116 he explains why he's discussed it at length and so on, and then he refers to that passage at the bottom of the page. That's paragraph 45, which you've drawn our attention to. And then in 117 he contrasts, I think, questions which are of policy or expediency, where safeguards are irrelevant. But it's the way he expresses his last sentence that just troubled me slightly. Have you got that passage?
Well, but my Lord, the reason I'm searching around is I think that is that not the famous passage that Lord Hoffman, to some degree, recanted
Well,
from
that may be the answer.
in Birmingham.
Yes, because that's the passage that that doesn't fit very comfortably. And is that the explanation?
Yes,
that he comes back
this
to
is
that?
a passage.
Yes.
Paragraphs 39 and 40 in Begum,
right.
which is at divided 20. This is the passage which caused some amusement.
So
I think I could
incautious,
say. Certainly at the bar,
yes.
yes.
Right. So
he suggested that perhaps he went a little far.
So it's paragraphs 39 and
39 and 40, my Lord.
Yes.
In 39, Lord Hoffman quotes himself in Alconbury at paragraph 117. Yes. And then at 40, he says, I have to confess that I think that was an incautious remark.
Yes.
The question in the Alconbury case was whether the appellate tribunal had to be able to review the Secretary of State's decisions based on policy. The extent to which it had to be able to review questions of fact did not arise. To decide that question, it is necessary to have another look at Brian.
Yes.
And then what you do is you go back to Brian, and as my Lord Brown will certainly know, one of the critical points about an enforcement notice appeal in the planning context is that once the facts have been found and the notice is upheld, then a breach of the enforcement notice gives rise to criminal prosecutions.
Yes.
And in accordance with the case of Crown against Wicks, it is not open on the Magistrates' Court or the Crown Court on the criminal prosecution to reopen the findings of fact. And what Lord Hoffman said in Begum, going on into 41 and 42, is that in that context, findings of fact in Brian were incredibly important and required particular safeguards. Yeah. And that comes back into my submission about you need to look at all these factors together, because the reason why in Brian you needed the safeguards wasn't just because it was a question of fact, it was because of what flowed from the decision-making process, which was potentially a criminal prosecution where your defence had already been undermined by the findings of fact. And that's what Lord Hoffman says at paragraphs 41 and 42 of Begum.
Well, thank you very much indeed. Let's set my mind at rest.
Then, my Lord, going on to deal with breach, what I'm going to do is make a few general points, but trying not to cover ground covered by Mr. Arden. Then I'm going to deal with Sophia and Crompton. Crompton briefly, but Sophia in a little more detail because Mr. Arden didn't do so. And then I'm going to conclude by just making submissions about those Brian factors and how they apply to this case. So in terms of the general points, as I say, I'll take it quickly. First of all, in my submission, the issues in the present case were decided in Begum. Although Begum concerned a challenge to a finding on suitability of the accommodation offered, the decision of the House of Lords was quite explicitly not limited to cases where the issue was one of judgment alone. And the argument being advanced today by my learned friend Mr. Gowdy was rejected in terms in my submission in Begum, and the references are Lord Bingham at paragraph 10 and Lord Hoffman at paragraph 58. So in my submission, where that leaves us is either can one draw a distinction on the facts of this case, or do Sophia and Crompton force this court to depart from the House of Lords decision in Begum. Dealing with the first of those, can one somehow draw a distinction on the facts? In my submission, the answer to that plainly has to be no. Part 7 of the Housing Act, decisions are based on a complicated nexus of facts and judgments. And some of what might be called simple facts then lead into difficult judgments. So there might be facts about whether the lifts work regularly in a block. And that's a classically simple question of fact. How often in the last 6 months have these lifts broken? It may be critical then to the question as to whether the accommodation is suitable for somebody with 2 small children who has to carry them up the stairs. Those are exactly the kind of issues that do arise in suitability cases. And in my submission, it is completely unrealistic to try to divide up these issues into fact issues and judgment issues. And to go that way, in my submission, is to invite absolute chaos, and I say that with care. In my submission, that is not too high. Absolute chaos in the county court, where some poor judge has to try to make these distinctions.
Well, I don't think there's much doubt that people would accept that when you're talking about whether the lifts work to decide whether something is suitable. But is it possible to isolate the kind of issue we've got here, which is a sort of make or break point as to whether or not the duty has been discharged on receipt of a letter?
Well, my lord, firstly, in my submission, my learned friend has been utterly unclear, perhaps deliberately unclear, on what findings of fact he says this approach would apply to. Now, at some points in his submissions, he suggested it was facts that did not require specialist expertise. And one can see that the lifts breaking would fall into that category, but they would be part of the nexus of suitability. At one point he suggested, in my submission, partly from the prompting of my Lord Brown, that it might be facts which could be said not to be staging posts. So can you draw certain facts away discreetly and say, well, those become facts which have to be amenable to a full fact-finding jurisdiction? Now, there are 2 points to make on that. One is, generally, that distinction will be very difficult to draw. The only way that it could perhaps be argued is to say, well, there's this one very distinct issue about did you get the letter or not. But in my submission, even that doesn't work. Because if you look at section 193(5 in volume 1, tab 1, the local housing authority shall cease to be subject to the duty under this section if the applicant, having been informed by the authority of the possible consequence of refusal and of his right to request a review of the suitability of the accommodation, refuses an offer of accommodation which the authority are satisfied is suitable for him, and the authority notify him that they regard themselves as having discharged their duty under this section. Now, the first point to make is an obvious one. Unlike Section 20 of the Children Act, the section subsection 1935 doesn't distinguish between different limbs that might be said, we're not talking about domestic precedent fact here, but that might be said within Article 6 terms somehow to be discrete questions of fact. You can see that even within section 1935, there are certain things that might be argued by lawyers to be discrete. Have you been informed? Did you get the letter? Have you been informed of the possible consequence of refusal? Now, is that a discrete fact or is that a judgment? In other words, that becomes, was the letter good enough? So you got the letter, that's not in dispute, but you say, but this letter didn't tell me about the possible consequence of refusal. This letter missed the point. So is that a discrete question of fact? And then, very similarly, of his right to request a review of the suitability, was that sufficiently clear? And then the next bit is, if the applicant refuses an offer of accommodation, well, you can see that that could be analysed as a question of fact. Did your letter back refuse the offer, or was it more equivocal? One can see in particular cases that might arise. And then which the authority are satisfied is suitable for him. Well, I think everybody would agree that was a judgment call. And the authority notify him that they regard themselves as having discharged their duty. Well, again, that could be, did you get the letter? But it could also be questions within the letter as to whether it was clear or not. So, my Lord, in my submission, attempts to try to divide off one particular factual inverted commas issue only is going to give rise to a domino effect of other potential factual issues that could be argued to be discrete or, in a non-domestic sense, conditions precedent. So, in my submission, the statutory scheme, statutory words, do not at all support an analysis that there are discrete questions of fact which can be wholly divorced from the rest of the Part 7 decision.
As a matter of interest, is there anything which actually dictates that these various bits of information have to be, or notification have to be in writing?
No, I don't believe there are, my Lord. There certainly aren't any, perhaps there are. Yeah. Yeah. If you fall into 1937, then it does 7A if it's made in writing. But that relates to a Part 6 offer.
Yeah.
Now, my learned friend tells me that in many of these cases there will be Part 6 offers as well as Part 7 offers. But there's nothing specifically, as far as I could see, because I did try and check this point, as far as I could see, there was nothing specifically in relation to Part 7 offers under 1935 that requires them to be in writing. And there's certainly nothing there's no statutory form. There's no specific letter or form or whatever laid down. So in my submission, the statutory scheme doesn't support this submission at all. I do also submit that it is relevant that this is not the way that Mr. Gowdy has ever put this case, as I understand it, before the promptings of yesterday.
I suppose until Mrs. Tomlinson dropped out, it would have been a bit tricky.
Precisely, my lord, precisely. This submission was completely contrary to what was being argued in Tomlinson. And I went back and checked the skeleton arguments and the judgment in the Court of Appeal, and there was no suggestion that it was being said that there were quite different issues around Ali and Ibrahim from these around Tomlinson. It is also relevant in my submission, and goes to the statutory scheme, that for Mr. Gowdy to win on this point would be what I would describe as a very Pyrrhic victory, because it's a very narrow point where, in most cases, I would suggest that's not going to be the issue that is arising between the individual and the housing authority. It's not going to be, I did get the letter or I didn't get the letter. It's going to be about suitability and issues around that. And then, of course, even if, in many cases, that very narrow issue about whether you got the letter or not is found in the claimant's favour, it still often won't answer the dispute, because then there may well go on to be arguments about suitability.
If there's been a refusal, of course.
Yes. But
Well, they just get another chance.
they'll get another chance, but it's often not going to deal with the substantive dispute. And in my submission, further on the statutory scheme, it's a completely illogical distinction to cut out this one narrow issue of fact and then leave other issues of mixed fact and judgment to be within the traditional point of law jurisdiction. And
one of the points, sorry,
no, please, no.
One of the points that was very powerful in the Croydon case, in distinguishing the Children Act from the approach in Pulhofer and the homelessness cases, was that the Children Act did not say if the local authority is satisfied that a person is a child. It had said that in previous, or words to that effect, or somebody who appeared to the local authority to be a child in a previous version of the legislation, but it didn't say that in the 1989 Act. Now, one of the points about Part 7 is that all the way through it says, if the local authority is satisfied, if the local authority is satisfied, about almost everything. Suitability, homelessness, this, that and the other, which suggests, of course, that a deliberate decision has been taken as to who is to be the fact finder in these cases. Now, to what extent is that relevant to what we have? It's relevant to the argument that Lord Brown raised about what's the difference between this case and Croydon. I'm not sure that it's relevant at all to the Article 6 point.
It's relevant to the civil right point, my lady, because it shows a highly discretionary scheme, a highly judgmental scheme, can I say, and it shows that the judgments are given to the decision maker, as was considered by Lord Hoffman in Birmingham about social welfare schemes. I suppose the point that would be made against me is that in 1935 it doesn't specifically say if in the opinion of the local housing authority the letter was received, but then you wouldn't expect it to. I mean, that is really my point about 1935. It's a totality. You read it together and those are all issues that run together. And whereas in Croydon, on the interpretation of the Children Act, one could see the argument that child was a separate issue where there were lots of judgments in the scheme for the local authority and there was no suggestion that the decision on whether somebody was a child was expressly for the local authority. But here, the issue of whether you get the letter hasn't been divided off into some separate section or some separate subsection. There's nothing on the statutory scheme that would suggest that that was the right approach. And indeed, it ends up with a real illogicality that you have this one matter which is subject to full fact-finding, and then everything else is subject to Section 204 point of law.
You could look at subsection 6, I think, as well, because looking at 6A, for example, in 6B, I think you would say these involve elements of judgment as well as to whether or not those tests for ceasing to be subject to the duty as well. So it's a very odd picture if one has some grounds for ceasing to be subject to the duty which are entirely within the judgmental area for the local authority, and then others where there's little bits and pieces in a composite package which have to be picked out and sent somewhere else. It's very untidy if that is the result.
It's extremely untidy, my lord, and the point I was making about subsection 5 is that my learned friend Mr Gowdy has focused in on the did you get the letter, but there are other parts of 1935 where you could argue they were questions of pure fact. And the poor old county court judge is going to have to try to decide which side of the line each part falls on. And my learned friend's only answer to that is say, well, that's simple enough. You look at the pleadings. But, my lords, in my submission, that is a very unrealistic approach to suggest that pleadings in a public law matter at the county court level are going to be so precise that the judge can confidently say, well, that's a full fact finder under Article 6 and that's a judicial review, Section 204 point of law. it's not at all fanciful in my submission to suggest all that you will get is a whole series of appeals to the Court of Appeal saying that the judges fell on the wrong side of the line.
Well, that's precisely the situation in Marina Beacom, isn't it? Because she said she'd been attacked by 2 youths. That's on that hypothesis, it'd be a pure question of fact
Yes.
to be taken separately and decided.
Well, I think that's why I said Mr. Gowdy was very unclear as to what he was saying was a pure question of fact, because on one of his submissions yesterday, he would have accepted that that was a stepping stone on the way to suitability, and therefore that would fall outside his pure question of fact. It's not clear to me where he says that the line would be drawn, because clearly, have you been attacked? Like, does the lift work, is a question of fact that ultimately can be determined by a jury. It doesn't need professional expertise. It's that kind of question of fact. So on the test he posited yesterday about is it a fact that requires specialist expertise, the answer has to be no. So in my submission, all you get to from Mr. Gowdy's submissions on this is a extremely untidy line, which has no basis in the statutory scheme whatsoever, and which inevitably will just give rise to huge amounts of litigation. Well, if Article 6 forced that, then so be it. But in my submission, Article 6 clearly doesn't force that. And while remaining on this point about what is a question of fact, in my submission, the other aspect of this is to emphasise the scope of Mr. Gowdy's argument here. Because if this court was to accept that questions of fact had to be dealt with by a full fact-finding tribunal, then that has implications that goes way, way beyond Part 7 in this case. And it starts to unscramble cases back to Alconbury. Because, of course, many planning cases, licensing cases, whatever, will involve pure questions of fact. And sometimes they'll involve them as what could be described as conditions precedent. So I just thought of one example over lunch. Listed buildings. Do the works fall within the curtilage of the listed building? That's a question of fact, ultimately. You have to have judgment, but a question of fact. Does that then become something that the High Court on a Section 288 appeal has to consider as a primary fact finder? One can see there's a huge...
There has been a time in my life when I could have wished that it did.
When your ladyship applied for an extension. Yes. But I think in a judicial capacity, it's not something that the administrative court would thank this court for. The point I make is that this argument goes well, well beyond Part 7 of the Housing Act and could be replicated across the field of public law, where the law has been settled since Alconbury that those are not decisions that need a full fact-finding jurisdiction. Then the final point I'd like to make before I come to Safio is just to stress the point that Mr. Arden made, which is that it is necessary for this court to look at the scheme as a whole and not to focus down wholly on the individual dispute. And the authority for that is, of course, Wright in the House of Lords and the speech of Lady Hale. And I do rely on that because effectively the government lost in Wright, because rather than looking at the individual facts and whether there was a breach of Article 6 or a breach of Article 8 on the individual facts, the approach of the House of Lords was to say, no, you've got to look at the scheme, and if you look at the scheme, it's not compatible. Well, if that applied in Wright against the government, it must apply here in our favour in terms of looking not at one factual dispute buried within 1935, but at the nature of the scheme as a whole. So I come then to whether or not Safio and Crompton force this court to depart from Begum and the settled position. And I am, I'm afraid, going to ask you to go back to Safio and to the key, which is divider... Oh, I may have written this wrong.
59.
Oh, sorry, 59. Volume 7,
Yes.
59.
Yeah. Thank you.
And the two key paragraphs, three key paragraphs of 45 to 47. And following on from the submissions I've already made about how one has to look at those Bryan criteria or those Bryan considerations holistically and together, not separately. In my submission, one has to read this passage in Saffaio together. What the European Court is saying is that if you put these factors together, you get a breach of Article 6.1. It's not saying each of these factors on their own would necessarily lead to a breach of Article 6. And if one just goes to the end of 45, there's consideration of Runa Begum there. And in the last sentence, any significant departure from the procedural rules would have afforded a ground of appeal. And then the first sentence of 46, the court considers the decision-making process in the present case was significantly different. And then there are two aspects in which the decision-making process was significantly different. First of all, the aspect in paragraph 46, which is that the issues raised in Begum and Bryan required professional knowledge or expertise, whereas the issues decided by a Housing Benefit Review Board was simple question of fact. That was one difference. And then the other difference was in 47. Now, just dealing with 46 first, my learned friend Mr. Gowdy says, but if there was a breach, Housing Benefit Review Boards had oral hearings and rights to representation. So if there was a breach there, then that would suggest that the position must be worse under Part 7. But in my submission, that does slightly involve taking the perspective of an English lawyer. Strasbourg does not place the same reliance on oral hearings as do most of us probably normally. And what they're saying in 46 and 47 is that Begum had the greater procedural protection precisely because of the impartiality problems that arise on the Housing Benefit Review Board. So it's just not right to read 46 and 47 to suggest that the European Court was thinking, well, even though there's all these procedural protections in the Housing Benefit Review Board, there's still a problem. Ergo, under Part 7, there would be less of a problem. That isn't the approach the European Court have taken at all. And when they talk in 46 about the facts and the good cause, being as the Housing Benefit Review Board was deciding a simple question of fact, the contrast there is with the kind of policy decisions which are inherent in the schemes in Bryan and Runa Begum, as opposed to the kind of decisions being made under the Housing Benefit Review Board, in this particular case, good cause. So Bryan and Begum are schemes replete with policy and judgmental questions, and of course, self-evidently, this case is exactly the same as Runa Begum, whereas a Housing Benefit Review Board was not a board, not a decision maker that required any specialist expertise. See the top of page 471. No specialist expertise required to determine this issue, which is, under the new system, determined by a non-specialist tribunal. And that's a factually quite important point about Saffaio, that, of course, by the time Saffaio got to the European Court, effectively, the pass had been, I was about to say the pass had been sold, but the position had been accepted by the UK government because the new housing benefit had been pulled in under the old Social Security Appeal Tribunal system. So the anomaly which had existed for years of councillors deciding housing benefit issues, which were exactly the same in many cases as the income support issues, had been swept away. So that's paragraph 46, but it is then important to focus also on paragraph 47, because 47 is all about impartiality. It's not about independence. The problem was that the European Court felt that these councillors were not impartial. Last sentence of 47, the safeguards built into the housing benefit review procedure were not adequate to overcome this fundamental lack of objective impartiality. Now, whether they were right or wrong in that approach to councillors isn't really the issue. What matters is that that's what Strasbourg was thinking about. And self-evidently, by their support for Runa Begum, they did not think that officers of local authorities suffered from the same difficulty. And to some degree, your lordships, your ladyship don't need to grapple with this today. But in my submission, the approach of the Strasbourg court is not unreasonable on this, because contrary to what Mr. Gowdy said, local authority members and local authority officers are not in the same position. Members are politically accountable, democratically accountable, and are associated very closely with the local authority. They are the political limb of the local authority, whereas employees, and we went through this at great length in Croydon, are subject to employment contracts. They are neither legally nor, in terms of public perception, associated with the local authority in the same way that councillors would be. And they also have their professional expertise to give them the training in impartiality, which might be said not to be so true of members. And it is, in my submission, it's very dangerous here to allow consideration of independence to start merging into impartiality. Mr. Gowdy has never made his submissions in this case on impartiality. His case is entirely clear, his written case.
But I mean, what's the objection to a lack of independence, except that it leads to at least the appearance of partiality?
I think it's a structural issue about being able to see publicly that it is a body, that there is some appeal through the system to a body which is wholly separate from the executive. I mean, I have always assumed that underneath all that there must be the two must merge at some point, I agree, but they are very clearly analysed as being separate issues in the case law.
You can be independent without being impartial.
Certainly.
Yeah.
Yes.
And you can be impartial without being independent.
Yes. The planning inspector is the classic example of that.
So clearly they are separate criteria, and it's going to depend on which structure you're looking at.
Well, you get that in the second last sentence of 45. Admittedly, that's just a rehearsal of Runa Begum, but it's the same sort of point, isn't it? That you can get a situation where there are sufficient safeguards to ensure that the admittedly non-independent person is conducting a fair review. Is that right?
Absolutely. There's no doubt at all that you can be not independent and wholly impartial. And I think, to me, the easiest example of that is the planning inspector, who, for completely structural reasons, is not independent of the executive, but has a whole gamut of safeguards for impartiality, which were discussed in Bryan and then in Alconbury. I think, with respect, the difficulty that Lord Brown is struggling with is one that I share. Underneath all that concern about independence must ultimately be that if you are not independent, there is some doubt about your ability to make a wholly arm's length decision.
Well, it's all water under the bridge, but in 1950 what they had in mind were courts in Nazi Germany.
Yeah, that's what I meant.
Yeah.
Yes, but without wishing to stray off the point, would the concern there about independence have been anything other than that body would have shown a partiality towards the government?
Probably not.
I suspect not. No.
That was why I said you could be independent without being impartial.
Yes, you could be
courts
independent.
are structurally independent, but from time to time there are examples where courts are either, in odd occasions actually, and in the case just mentioned actually, and in other cases have the appearance. But the argument that was put before us in Croydon was that judicial review is fine to deal with actual bias, actual lack of impartiality, but if you aren't independent, it's not so easy for that to deal with lack of apparent partiality. So it's a similar point to the one that my lord is making.
Yes, but the answer here is to some degree easier than the answer in Croydon, because my learned friend has not put his case on the basis of impartiality as it was put in Croydon. And in Croydon, there was reams of evidence and case law and submissions on why local authority officers should not be considered to be partial, why they were genuinely impartial. And if that was the case that was being made, then there are extensive arguments that can be made against it. Here, the allegation of breach of Article 6.1 that until oral submissions Mr Gowdy was plainly making was only about independence. Now, if they now start to stray into impartiality, then in my submission, the answer to that lies in Croydon, where the issue was dealt with. And if I ask your Lordship and your Ladyship take up the opinion, Lady Hale's opinion in Croydon at paragraph 44, dealing with alleged, it starts at 43, I'm sorry, where Mr Howell argues that social workers deciding upon Section 20 claims cannot be impartial because they are employed by an authority with a direct financial interest in the outcome. Well, the argument here, if it was about impartiality, would be exactly the same. And then Lady Hale says at paragraph 44, I would be most reluctant to accept, unless driven by Strasbourg authority to do so, that Article 6 requires the judicialisation of claims to welfare services of this kind. Unlike the arguments based upon statutory construction and jurisdictional fact, Mr Howell's argument cannot sensibly distinguish between the determination of age and the determination of other criteria of entitlement. Every decision about the provision of welfare services has resource implications for the public authority providing the service. Public authorities exist to serve the public. They do so by raising and spending public money. If the officers making the decisions cannot be regarded as impartial, and the problem cannot be cured by the ordinary processes of judicial review, based upon the usual criteria of legality, fairness and reasonableness or rationality, then tribunals will have to be set up to determine the merits of claims to children's services, adult social services, education services and many more. Resources which might be spent on the services themselves will be diverted to the decision-making process. Such a conclusion would be difficult, if not impossible, to reconcile with Runebagum. The degree of judicialisation required of an administrative decision in the view of Lord Hoffman in Alconbury depends upon the nature of the decision. Now, in my submission, the passage in the middle of that paragraph about the role of local authority officers and of local authorities applies in exactly the same way here. The officers have no financial interests. The local authority is there, as my learned friend Mr Arden said, to provide housing.
Are you suggesting that the paragraph would have been differently written if instead of the word officers it had said members or whoever the elected people are?
Well, my lord, on the arguments in Croydon, if the Section 20 age determination had been made by councillors, then the arguments would have been very different because councillors had no specialist expertise. They, on the basis of Sophio, might be said to have a close interest, but one would then, I suspect, have got into arguments about to what degree was Sophio about the fact that there was this financial penalty on the local authorities if they found good cause. I don't know if your lordship remembers, but the subsidy regime was such that the local authority...
If you're allowed to claim retrospectively, you pay 50% instead of 45 or something. No, I mean, it's much more than that, I'm sorry. I know what it is.
No, I think it's 95, but it doesn't matter very much. Yes. And of course, although the actual financial impact on the local authority is probably relatively slight, it could have been quite a severe incentive on members. At least that seems to have been the thought process of the Strasbourg Court.
It's a very interesting thing, isn't it, about the relevance of democratic accountability to all of this. There are 3 or 4 paragraphs in Lord Hoffman's speech in Runebagum which talks about democratic accountability. But of course, it's because of the democratic accountability, i.e., your voters may vote you out if the council tax goes up as a result of your generosity to the locals, that people might be regarded as not independent and impartial. So it's quite an ironic state of affairs.
Yes, and as far as I'm aware, there's been no case post-Sophio on the equivalent of politicians making decisions elsewhere in the signatory states, and it will be interesting to see what, if anything, Strasbourg does next with that line of thought, and how critical it actually was in Sophio as compared to the fact which comes out in Crompton that it didn't need to be a specialist tribunal. It could perfectly well be an ordinary lay. There was no reason in Sophio or in Crompton for it not being a non-specialist tribunal, and therefore that may have fed into the view on Article 6. But one can only speculate as to where the European Court will go next.
The court did seem to draw something from Mr. Justice Moses in Bury, didn't it? Page, I'm taking this from paragraph 47, which is really the source from which they seem to have drawn the idea of councillors having been affected by the financial consequences. And then is there something in Mr. Justice Moses' discussion at page 466 that picks this up? First paragraph, if councillors directly connected to one of the parties dispute the council,
Yes,
and
although
then halfway down...
Of course, if one was going to try to unravel this line of case law, it is quite important to note that Bury predated Begum, and Bury appears to have been very influenced by Lord Hoffman's unguarded comment, or however it was he described
in Alconbury. Yes.
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 So the sequence was
see.
Alconbury, Bury,
Yes.
Begum.
Yes.
And after
Yes.
Alconbury, there was a great deal of discussion at the English Administrative Law Bar about what did Lord Hoffman mean by safeguards,
Right.
and what safeguards did you need? And everybody was thinking you needed something like a planning inspector. And that was the point where Mr. Justice Moses made the decision in Bury. Then Lord Hoffman came along in Begum and said, well, sorry, that was a bit of an unguarded comment. And the position changed. Now, that's not to suggest that Strasbourg was unduly influenced by Bury, but it does perhaps explain Mr. Justice Moses' comments there on Alconbury.
Yes.
When we come to Crompton, I mean, that doesn't pick up 47 at all, does it?
No.
No.
No. Crompton, which is in volume 6, divider 37,
Paragraph 73, isn't it?
Yeah.
Paragraph 73, the court refers to Sophio, but the point they pick out of Sophio, and this is what I was referring to a moment ago, is the one about no specialist expertise was required to determine the issue, top of page 13. Nor could the factual findings in Sophio be said to be merely incidental to the reaching of broader judgments of policy or expediency, which it was for the democratically accountable authority to take. So those are clear distinctions in Crompton from Sophio.
But it's when they go on to say accordingly, without mentioning the impartiality point,
Yes.
Yes.
that gives rise to the argument that if it's not specialist and it's factual, then it requires the court to determine it.
Well, my lord, those were the issues that arose in Crompton. And so perhaps to that degree it's not surprising they didn't make very much of paragraph 47. But even taking Crompton on its own terms, in my submission, the critical point about 73, which then comes up in 77, is that it was a decision-making structure where there was no need at all for professional expertise, and where the decisions that had to be made, what's the amount of your redundancy compensation, were factual decisions rather than judgmental ones, which have effectively turned on adding up what you thought the entitlement was. And when one comes to 77, I won't read through the first part of it again, but you come on the second page at about line 5. Accordingly, there was no compelling reason for the decision on the level of compensation to have been made by the Army Board rather than by an independent and impartial tribunal. In this respect, therefore, the court considers that circumstances are similar to those in Sophio. So what we were looking at was a scheme that didn't involve the policy stroke expediency issues that were part and parcel of Bryan and then part and parcel of Begum. So that's the distinction that was being drawn there. And in my submission, there's nothing in Crompton that casts any doubt whatsoever on the analysis in Begum because of that distinction about the nature of the schemes. Clearly, all that the European Court in Crompton thought it was doing was following that part of Sophio. And what is so interesting about Crompton is that if one then goes on to 78, it brings home that, again, you have to look at the matter holistically and all those different Bryan elements, because actually there was no breach in Crompton. Because of the nature of the decision that was being made, and because of the scope of the High Court in respect of that particular decision, there was no breach. So that's one of the factors that has to be pulled in there. So for those reasons, in my submission, neither Crompton nor Sophio in the slightest require this court to depart from the House of Lords decision in Begum. Can I then just conclude on breach by going through those, the various criteria, or the various considerations is better than criteria.
Yes.
And I'm going to do this quickly because it's in my written case, and it's to some degree just pulling together what I've already said. First of all, looking at the subject matter of the decision, this is a case which at its highest is on the periphery of being a civil right. Secondly, as was said in Runa Begum, it is a highly policy-driven scheme, replete with evaluative judgments. And thirdly, it involves what Lord Hoffmann described as a classic exercise of administrative discretion. So those are the factors in subject matter of the decision.
And how do you identify the scope of the subject matter? Do you look at at subsection 5, or are you looking more broad?
In my submission, my lord, at this stage, you look at the broader
Yes.
approach. You look at part 7 and the subject matter of the decision as a whole.
Well, you'd have to do that, don't you? Because part of the point is that the duty to provide accommodation, or secure that accommodation is provided, that's subject to section 206, which says that the accommodation has got to be suitable. So you're not just looking at section 1935, you're looking at bits that are elsewhere in the scheme.
It all has to come together. Absolutely.
Yeah.
Then you look at the nature of the issues that arise. And the issues that arise under this scheme are those that, in general, require professional judgment and expertise. Looking at the scheme as a whole, it is not a scheme where there are simple questions of fact that lead to the end conclusion, like Manito or Sophio. And yes, there may be factual disputes in there, but that's part of the decision-making process which requires the professional judgments. And then you look at the content of the dispute itself. Here, the alleged breach of Article 6 is that the reviewing officer is not independent. That is exactly the same as the argument in Runa Begum. It is in contrast to the argument in Safio, but also, to put it in the context of the case law, it's in contrast with a case like Wright, where the court may remember that in Wright, the alleged breach of Article 6, or well, the found breach of Article 6, was a complete denial of any right to make representations. So and the consequence of that decision was that the person usually lost their job. Not always, but on the facts, that was very often going to be the result. So you've got a major departure from the principles of a fair trial, fair hearing, combined with a very draconian consequence. Whereas here, you've got structural lack of independence, but in terms of that breach and the consequences of that breach, nobody suggested the consequences aren't serious, but they're not, in Article 6 terms, the same as losing your job. Because of the, I'm sorry, I should explain that, I'm getting into shorthand at this stage, because that is such a clear attack on your private law rights. The consequence in Wright was you had a private contract of employment, and that had to be terminated by statutory process if you were put on the provisional list. So that is an absolutely classic central civil right that has just been interfered with. Whereas here, we are on the absolute edge of Part 7 rights, and whether they are Article 6 rights at all. So you can see the way all these issues intermesh in each other.
Does the fact that you could apply again have a part to play in this? Or is that really just something best left out of the account?
Well, my lord, if it has a part to play, my submission, to be fair, would be that it's probably a relatively small part to play, because it seems that you can only apply it. Your application is only likely to be seriously considered if there's been a material change of circumstance. And if you simply stick in another application on the grounds that the decision maker says they didn't get your letter, then my understanding of the case law is that you're likely to get fairly short shrift from the local authority. So, my lords, conscious of the time, those are my submissions on breach. Can I then come finally to remedy? The Secretary of State's position is that if you're against me on everything that I've already said, then this is a case where it would be appropriate to exercise the powers in Section 3 rather than to make a declaration of incompatibility. And I don't think I actually need to take your lordships and your ladyship to the passage. Guidan, Volume 3, Divider 14, paragraphs 30 to 33.
Yeah.
You can read words in that change the meaning, but you can't adopt a meaning which is inconsistent with a fundamental part of the legislation. In my submission, reading Section 204 to allow a right of appeal which extended to the consideration of facts, if that was what Article 6 required, would not be changing a fundamental part of the legislation. It would certainly be changing the meaning, and indeed it would quite clearly be reversing what Parliament intended in 1996, but on my understanding of Guidan, that is acceptable as long as it's fundamental to not fundamental to the legislation. Now, what I would say is that it would not, on my learned friend Mr Gowdy's submissions, be at all easy to draft that new term of Section 3 as to precisely when this enhanced judicial review power would apply. But that doesn't mean you can't use Section 3. It merely shows the problems with my learned friend Mr Gowdy's arguments. Because if it was simply a question, this has turned into a complete merits review under Section 204, and every issue could be considered, had to be considered in full, then that would be easy enough to draft. But trying to draw this very muddly line that he suggests will be if your lordships find against me, be a major struggle, I suspect.
So you mean to draft the circumstances in which this enlarged jurisdiction would apply?
Yes.
would be difficult.
Would be very difficult.
Although you can describe what it is, it's just when you should venture into that area, because if you don't define it tightly, it's going to have very wide implications.
Yes.
Is that the point?
And if you do define it tightly, then it's going to be endless debate as to whether the line's in the right place. And if you don't define it tightly, then it's going
to be endlessly
It's going to be endlessly well, it's going to be endlessly argued over. But that isn't an argument against using Section 3.
Well, the technique, of course, that has been employed is except when it will be incompatible with X's rights under Article 6, so to confine the appeal.
Yes.
We've done that on a couple of occasions. But that would simply lead to endless arguments about what was and was not required by Article 6.
Yes, and those arguments may not get back here, but they will certainly keep the Court of Appeal busy for some time.
Yes. It is a very difficult exercise. R&A number 2 we were shown yesterday, I think, and I recall that very well. It was extraordinarily difficult to think of a formula which would be intelligible, really.
And we did it in Hammond.
Yes, that's
We did it in Hammond, which is whether or not you had to have an oral hearing on a fresh look at how long you have to spend with life sentences and the rest of it. And I think we simply said, because the legislation said no oral hearing, and we simply rewrote it to say oral hearing when necessary in the interest of justice. I'm not conscious that that's actually given rise to any great problems since.
Yes, I'm not familiar with the facts on Hammond. I do wonder rhetorically whether they arise quite as often as Part 7 appeals and the issues in this case, but I may be wrong on that, as I say. I
think the difficulty is the line drawing exercise that we're being asked to engage in here, because it hasn't been argued that we should depart from the line that was drawn in Runa-Begum. It's just been argued that the line that's now being talked about wasn't considered in Runa-Begum, and it's very, very difficult to work out where it would be.
I would submit strongly it would be very difficult to work out, and that's a fundamental part of my argument. But at this stage, I'm on remedy, and it still, in my submission, is appropriate to use Section 3. My Lords, my Ladyship, unless there's anything more, those are my submissions on behalf of the Secretary of State.
Thank you very much indeed. Yes, Mr. Gowdy.
My Lords and my Lady, the fundamental point we submit on these appeals is that the law has moved on since Runa-Begum. The Strasbourg decisions in Sophia and now Crompton strike a rather, if not very different note. My learned friend Mr. Arden relied heavily yesterday afternoon on the speech by Lord Hoffman in Runa-Begum. If, however, one takes Lord Hoffman's approach in Runa-Begum in its entirety and applies it to the facts in Sophia, then Mrs. Sophia loses. But of course, Mrs. Sophia, in fact, won. Mr. Arden emphasised, in particular, paragraph 56 in Lord Hoffman's speech, and especially the statement that a limited review of the facts is sufficient in those areas of the law, such as regulatory and welfare schemes, in which decision-making is customarily entrusted to administrators. That approach, applied to housing benefit, would yield the answer that Mrs. Sophia should have failed. What Lord Hoffman said in that respect is capable of applying every bit as much to housing benefit as to homelessness. But although in Runa-Begum homelessness lost, in Sophia housing benefit won, so assuming Runa-Begum as well as Sophia to be correctly decided, the distinction must be something other than the homelessness scheme on the one hand and the housing benefit scheme on the other hand. The distinction must be the distinction we suggest made in Sophia itself, the distinction between expertise/discretion issues such as suitability on the one hand and fact issues on the other hand, such as in both the Sophia and the present appeals. And indeed, we respectfully suggest that the approach should not be to ask oneself what is the least extent to which one has to chip away from Runa Begum. The approach should be to ask oneself, are the principles in Safio applicable to the present case, or is the present case distinguishable from Safio? If the music had stopped with Safio, we submit that the answer is clearly that the present appeals are Safio cases, not Runa Begum cases. And if there were any doubt about that, it's entirely dispelled by the way in which Safio has now been dealt with in Crompton. Lord Kingsley in the United Kingdom, the Gaming Board case, is a clear instance of a case on the other side of the line from Safio and these appeals. That is, it is a case on the Runa Begum side of the line. Kingsley, of course, having been concerned with who is a fit and proper person, and that, of course, being akin to what is or is not suitable accommodation. These, on the other hand, the present appeals, are cases where, unlike in Runa Begum and Kingsley and cases of that sort, the factual issues are not incidental, but are discrete. In Runa Begum, Lord Hoffman, at paragraphs 51 to 52 and 56, described the decision as to suitability as the subject matter of the decision and as a classic exercise of administrative discretion. Here, the subject matter is entirely different. It is not suitability, and it is not something else which is a classic exercise of administrative discretion.
But you're reading the word subject matter quite differently, aren't you, from the way Sleven put it just a few moments ago. You're saying you look precisely at the very issue as to whether or not the letter was received. Is that right? Are you narrowing it down as much as that?
Well, it does come down to that, in that in this instance, and I'm coming to this shortly, that if one takes the three, one appreciates it's not an exhaustive list, but if one takes the three criteria that are, so to speak, highlighted in Bryan, in this case, the subject matter of the decision and the nature of the dispute come very close to one another, namely the issue of whether one expresses it as an issue of fact or an issue of credibility. But here, the dispute is about a discrete factual issue, however one describes that issue. It is certainly not a dispute in whole or in part about suitability. And as the court has seen many times now, subsection 5 of section 193 is in two parts. The authority ceases to be under the duty if first the condition is satisfied that the applicant has been informed of the consequences, and if so, secondly, the offer that is refused is of suitable accommodation. And in our submission, the question whether the precondition is satisfied, what I earlier described as a gateway, is a discrete question. As Lord Brown has put it, there is a completely independent precondition, a separate parallel inquiry, not a staging post. So in terms of the three...
But can I just be clear? I mean, is that now your case? I mean, are you narrowing it to the receipt of letters? Now that Mrs. Tomlinson is separately catered to.
These are appeals are about the receipt of letters. And one is not therefore concerned specifically to argue the position in relation to intentionality, the issue in Tomlinson. But I accept, as I've always accepted, that in terms of what are discrete issues of fact under Part 7, that is by no means necessarily confined to the question of receipt of letters. There may be other examples, just as there are examples, in addition to suitability, of matters that are evaluated.
What about how often the lifts work? Is that fact or is that evaluation?
Well, that only comes in the context of evaluation, There's nowhere in the legislation where there is a requirement in relation to lifts working or any conclusion following from a factual finding that lifts don't work. Whether or not lifts work simply goes into the consideration of the suitability of the accommodation, and that therefore is a classic example of a factual inquiry which is incidental and ancillary to the determination of the suitability issue and is merely a staging post on the way to the determination of the suitable issue. So that is on the other side of the line. And my Lord, so in terms of the three highlighted Bryan criteria, the subject matter of the decision is whether a letter in particular terms has been received, and that is very different from Runa Begum, and is actually a fortiori to Sofio in terms of being a factual subject matter. The content of the dispute is whether the denial of receipt is credible. That, again, is very different from Runa Begum, and again is a fortiori to Sofio in terms of being a factual dispute. All that differs between Runa Begum and the present cases on the one hand and Sofio on the other hand is the manner in which the decision was made, the difference between an officer decision and a panel of councillors' decision. That difference, however, in our submission is peripheral, both because comparing the two schemes, homelessness and housing benefit, it is not a material difference because homelessness reviews can be by councillors or by officers, and because in terms of independence and impartiality, there's not much difference between officers and councillors. Councillors, as my learned friend Mr. Arden acknowledged, are subject to codes of conduct which govern their conduct generally, not only their conduct in the one respect he highlighted for his purposes, their conduct towards officers, but also, and more importantly, their conduct towards the recipients of the council's services. Like officers, councillors do not have a personal financial interest in the outcome. Like officers, they have an interest in their authorities' finances and resources. So one shouldn't over-denigrate councillors, and their democratic accountability is a reason for not interfering with their decisions, not the contrary, as Altenbury and other cases demonstrate. And nor, on the other hand, should one praise officers. They are, of course, at one with councillors in properly seeking to help the homeless. They are, of course, at one with councillors in properly seeking not to prejudice unduly, more than necessarily, those who are on the authorities' housing waiting list. But officers may, as readily as councillors, get the balance wrong. From time to time, authorities, not excluding Birmingham, are criticised for failure on the part of its officers to treat the homeless fairly. So officer decisions are neither inherently nor in practice markedly superior as a class to councillor decisions as a class. This is not a distinction that one should make too much of. And in our submission, the manner of decision, therefore, is a minor difference between our case and Sofio, and given Crompton, is not to be regarded as being a major feature of Sofio.
Yes.
My lords and my lady, as regards whether the appellant's undoubted rights are civil rights, it's now, of course, firmly established that rights are not prevented from being civil rights because they have a public nature. The law has, as Miss Leven accepts, moved on since Felderbrugge, and the test is as stated in Salesi and Menito as regards social security and in our submission social welfare benefits, that is one talking about an individual economic right flowing from specific rules laid down in a statute. That is the test upon which we seek to rely, and Strasbourg has not carved out an exclusion for benefits in kind. On the contrary, it has extended property rights by accepting, in a series of cases, that a property right can be constituted by a legitimate expectation. And that is supported by the Italian POW case in an earlier passage than those to which the court's attention has been drawn so far, paragraphs 62 and 64, referring to Capecchi, and as the court has seen, by the Tetterini line of authorities, Tetterini itself at paragraphs 45 to 47. But here, the right is more crystallised and stronger than simply a legitimate expectation. If the criteria are satisfied, then the right exists. There is no discretion. There is a duty. The fact that the duty may be discharged in different ways, provided always that it is discharged, does not detract from the right. And you do not need a judgment in your favour in order to have achieved the right. A right to pursuant to statute is as much a civil right as a right pursuant to a judgment. If statutory rights exist, they do so whether or not a court has declared that they exist, or, if they've been denied, a mandatory order has been made with respect to them. A court order is not necessary in order for civil rights to crystallise, and were the position otherwise, it would be somewhat fortuitous and arbitrary. And the identification of a particular property is not an ingredient of the existence of the right. A right to have accommodation provided or secured for one is itself a discrete right. It's not emasculated as such on account of separate questions that may arise in relation either to the performance of the duty or to the cessation of the duty. And the Part 7, Section 193, subsection 2 right, indeed contrasts in that respect with the non-rights under Part 6 of the same Act. And the Part 7 Housing Act scheme, the homelessness scheme, is moreover similar to, rather than different from, cash benefits in having evaluative elements. Of course, if, contrary to our submissions, one is looking at the scheme as a whole, then one can indeed point to evaluative elements in the homelessness scheme. But so too the housing benefit and other cash benefit schemes contain evaluative elements. By way of example only, housing benefit evaluation includes considering whether there's a sham arrangement, whether there's been a deliberate deprivation of capital, an evaluation which compares rather with intentionality in the homeless scheme. And I think the one bundle the court hasn't looked at so far is Volume 2, which is devoted entirely to the housing benefit regulation. I think it's in fact the current regulations that are there rather than earlier versions, but the same point can be made by reference to earlier versions. And just by way of illustration, the court will see at page 30, Regulation 9, circumstances in which a person is to be treated as not liable to make payments in respect of a dwelling. The liability to make payments in respect of a dwelling, of course, being a crucial element in relation to eligibility for an entitlement to benefit. But circumstances which in effect will mean you will be denied benefit for which you would otherwise have been eligible include in subsection 1 of section 9 that a person who is liable to make payment in respect of a dwelling shall be treated as if he were not so liable, where any one of a dozen or so circumstances exist including little a, the tenancy or other agreement pursuant to which he occupies the dwelling, is not on a commercial basis, clearly an evaluative issue. That's the very first one. And if one takes the very last, little l, halfway down page 31, in a case to which the preceding subparas do not apply, the appropriate authority is satisfied that the liability was created to take advantage of the housing benefit scheme. So it's not a simple
I have
matter.
a feeling we've been there before, Mr. Gowdy, haven't we?
Yes, we have.
This regulation, you and I, in some case or other, yes.
Indeed. A case which I lost in the Court of Appeal, but which was subsequently overturned in a different case, the RJM case in the House of Lords, I think, in which I'd been the first instance judge. So it all gets rather rather incestuous, my lord, yes. But, my lord, therefore one sees that housing benefit involves a mixture of evaluative questions and mere arithmetical mechanics and so forth, and the same is true of homelessness scheme, that one has elements of both. And one can take that with other financial benefits as well. For example, the case of disability living allowance, there's a mobility component which may be at a higher or a lower rate, and or there's a care component which may be at a higher or a middle or a lower rate, all depending on evaluative judgments as to the severity of needs and so forth. So that is a feature that is not peculiar to homelessness as compared with cash benefits of one kind or another, including but not confined to housing benefit. In our submission, Woon, Bron and Loiseau are entirely different cases, and the admissibility decision in Steck, we submit, supports our case in at least two respects. First, it's based on the Strasbourg decision in Schule-Schragen against Switzerland in 1993, and the passage which is quoted in the Steck admissibility decision from Schule-Schragen, that the court there had held that the development in the law and the principle of equality of treatment warrant taking the view today that the general rule is that Article 6.1 does apply in the field of social insurance, including even welfare assistance. Now that's an important statement of principle for at least two reasons. One is that it is stating a general rule, and the second is that it's not confined to social insurance, but extends to welfare assistance. Secondly, Steck, in the immediately following paragraph 48, equates possessions under Article 1, Protocol 1, with pecuniary rights under Article 6. And here, of course, there are, the right is a right to be provided with accommodation. And Sophio itself is important in this connection. At paragraph 40, under the heading the court's assessment, paragraph 40 begins.
Sorry, what is this in right?
No, my lord, Sophio.
Sophio, sorry, yep.
Volume 7 of the authorities at tab 59.
Paragraph
59, tab 59, paragraph 40. Under the heading B, the court's assessment, and the very first sentence of paragraph 40, the court recalls that disputes over entitlements to social security and welfare benefits generally fall within the scope of Article 6.1, with a footnote reference to the earlier cases. And again, that's significant for two purposes. One is because it is describing the general rule, and secondly, because it is describing the general rule in terms not only of where at one time one may have started, namely social security, but also welfare benefits. So the law has developed. It may have started only with contributory social security benefits. It then extended to non-contributory benefits, but it's not confined to social security. It extends to, in the language of Schuler-Scragen, welfare assistance, in the language of Sofio, welfare benefits. And surely the homelessness scheme, beyond any doubt, is a scheme of welfare benefit or welfare assistance. And therefore, in terms of the applicability of Article 6.1, comes within what is expressed as being the general rule. And therefore, in our submission, ultimately, it's a relatively short point that the issue on this appeal is whether an exception is engaged which displaces the general rule. And in our submission, our case is that there is simply no justification for any such exception. And that's ultimately what the case and the appeals boil down to.
Thank you very much indeed. Well, we're very grateful indeed to counsel on both sides and to the intervener for their assistance, both orally and in writing. A very great help to us in a short but very important point. The court will take time to consider its decision.